Nobody is telling Karmelo Anthony's supporters the full story. The organizations rallying around him, the social media advocates calling the conviction a travesty, the voices demanding justice and pointing to the all-white jury and the 35-year sentence and the Batson challenge that the judge denied. All of them are focused on one thing: getting that conviction overturned. And they may be right that there are genuine legal grounds to fight for. They may be right that the jury selection process raised constitutional questions worth examining at the appellate level. But there is something almost nobody in that conversation is saying out loud, something the fundraising pages are not mentioning, something the advocacy organizations are not posting about, something that the people building their entire online presence around the fight for Karmelo Anthony are, for whatever reason, leaving out of the picture almost entirely. If this appeal succeeds, Karmelo Anthony could end up in a far worse position than he is in right now. This is True Crime Vault, and today we are going to talk about the part of this legal story that gets left out. The architecture of risk that sits underneath any appeal of a murder conviction in Texas, why winning can be more dangerous than losing, and what the legal system actually does when an appellate court decides a trial was flawed. We are going to look at the Batson challenge, the sudden passion argument, the retrial framework, and the full picture of what Karmelo Anthony and his legal team are genuinely navigating right now. Before we get into it, please subscribe to True Crime Vault right now and hit that notification bell. We go deeper than the headlines on every single case we cover, and we follow these investigations long after the verdict. Hit the like button too. It genuinely keeps this channel going. Now let's get into it. First, let us establish what has actually happened since June 9th, 2026, because the timeline matters and some of the reporting around it has been imprecise. On June 9th, 2026, a Collin County jury found Karmelo Anthony guilty of murder for the death of Austin Metcalf. Austin was 17 years old when he died on April 2nd, 2025, at David Kuykendall Stadium in Frisco, Texas, during a high school track and field event. The jury sentenced Karmelo Anthony to 35 years in state prison. He was 19 years old at sentencing. On June 10th, 2026, defense attorney Michael Howard filed a formal notice of appeal with the court. That same day, court records indicate that Karmelo Anthony filed what the legal system calls a pauper's oath, a formal declaration of financial indigency, asking the court to appoint publicly funded appellate counsel because he cannot afford private representation for the appeal. On June 10th, Anthony was also transferred out of Collin County custody into the Texas Department of Criminal Justice, beginning the intake process at the Huntsville facility. He is currently serving his sentence while the appeal moves through its early stages. The case now belongs to the 5th District Court of Appeals in downtown Dallas. The appellate process is not fast. Months will pass before briefing is complete. More months, possibly a year or more, before the court issues a ruling. And that ruling, depending on what it says, sets off a chain of events that virtually no one covering this case is explaining clearly. So, let us explain it clearly. An appeal is not a second chance at freedom. It is an argument to a higher court that the original trial was legally flawed in a way that affected the outcome. Appellate courts do not hear new witnesses. They do not evaluate new evidence. They do not reweigh what happened under that tent on April 2nd, 2025. What they do is review the official trial record, every page of transcript, every ruling the judge made, every objection that was raised, every piece of evidence that was admitted or excluded, and determine whether the rules of the legal system were followed correctly. If the appellate court decides the rules were followed correctly, the conviction is affirmed. Everything stands. 35 years. Karmelo Anthony serves his sentence, becomes eligible for parole consideration after approximately 17.5 years, and the legal chapter of this story is over. But if the appellate court decides the rules were not followed correctly, if they find that the trial was legally flawed in a way that violated Karmelo Anthony's constitutional rights, then something very specific happens. And this is the part that almost no one in the public conversation is discussing with any honesty. The conviction is reversed, and a new trial is ordered. Not freedom, a new trial. Every person who donated to Karmelo Anthony's fundraising campaign, every person who shared the posts calling this conviction a travesty, every person who has been demanding justice through an appeal, What they are actually pushing for, if the appeal succeeds, is for Karmelo Anthony to go through this entire process again. New jury selection, new opening statements, new witness testimony, new deliberations, a new verdict. And here is the part that makes experienced criminal defense attorneys extremely cautious about appellate strategy in murder cases. In Texas, if a conviction is reversed on appeal and the case goes to retrial, the second jury is not bound by the first jury's sentence at all. The first jury said 35 years. If the second jury finds Karmelo Anthony guilty of murder, and they are hearing all of the same evidence, the same body camera footage, the same testimony about what happened under that tent, they can sentence him to anything within the legal range for a first-degree murder conviction. In Texas, that range for an adult defendant is 5 years to 99 years, or life. Let that sit for a moment. A successful appeal does not cap the second jury at 35 years. It does not tell the second jury that 35 was the right number, and they should stay near it. It hands them a blank slate and a full range from 5 to 99 or life. And the prosecution, who now knows exactly what the defense strategy looked like, who has had months or years to prepare, who has already heard every argument the defense made the first time, gets to present their case again with full knowledge of what they are up against. The advocates who are loudest about this case being a travesty and this appeal being a righteous fight owe the people who care about Karmelo Anthony an honest accounting of that risk, because the loudest voices in this conversation are not the ones who will be sitting in a retrial courtroom. Now, let us be equally honest about the legal argument itself, because it is not frivolous. The Batson challenge at the center of this appeal is a real constitutional issue that deserves serious analysis. The Batson principle comes from a 1986 United States Supreme Court case called Batson versus Kentucky. The ruling established that prosecutors cannot use peremptory strikes, the free passes they get to remove jurors without giving a specific reason, to exclude prospective jurors because of their race. It is a constitutional prohibition rooted in the Equal Protection Clause of the 14th Amendment. It exists because an all-white jury in a racially charged case involving a black defendant is not an incidental outcome. It is a structural problem with implications that extend far beyond any individual verdict. During the jury selection phase of Karmelo Anthony's trial, which began June 1, 2026, the prosecution used 3 of their final peremptory strikes on the last 3 black prospective jurors remaining in the pool, every single one. Defense attorney Michael Howard stood up immediately and filed a Batson challenge. He argued to Judge John Roach Jr. that 100% of the available black prospective jurors in the strike zone had been removed, and that this systematic removal was racially motivated. The prosecution responded with what the law calls a race-neutral reason. Their explanation was that all 3 of the women they struck were educators, teachers, or people who worked in educational settings. In a case centered on a school-sponsored event with student witnesses involving teenagers at a high school track meet, they argued that people who work professionally with school-aged children might bring inherent sympathy toward young defendants in their professional capacity. Bias rooted in profession, they said, not race. Judge Roach accepted that explanation. He denied the Batson challenge. The jury was seated, and on June 3, 2026, the final panel, 12 jurors and 6 alternates, contained no black jurors. The jury that convicted Karmelo Anthony of murder and sentenced him to 35 years was composed entirely of white, Asian, and Hispanic members in a case that had, from its very first day, been understood by the entire country as having a significant racial dimension. At the trial level, the bar for defeating a Batson challenge is genuinely low. A prosecutor does not need to prove their race-neutral reason is the true reason. They only need to offer a reason that sounds plausible on its face. Trial judges almost routinely accept these explanations because the system gives them significant deference to do so. That is why Batson challenges almost never succeed at trial. But appellate courts are different. When an appellate court reviews a Batson claim, they conduct a more thorough analysis. They look at the complete voir dire record, every question asked of every prospective juror, every answer given, every follow-up, every strike made by both sides. and they ask a very specific question that the trial court did not fully probe. Were there white prospective jurors in that pool who shared the same characteristics as the black jurors who were struck? And were those white jurors allowed to remain? That is the crucial question. If the prosecution's race-neutral reason was really about educators, about professional sympathy toward young people in school settings, then that concern should have applied equally to white educators in the pool. If there were white prospective jurors who also worked in education, or who had other comparable characteristics, and those people were not struck, then the race-neutral explanation starts to look considerably less race-neutral. The entire voir dire transcript is on the official record. Michael Howard and his appellate team, whether that ends up being his firm or court-appointed counsel, are going to go through every page of it looking for exactly that kind of inconsistency. One white educator who was seated on that jury. One white juror whose questionnaire answers resembled the black jurors who were struck. One documented asymmetry in how the prosecution treated similarly situated jurors of different races. If they find it, the appellate court has real grounds to reverse the conviction. SMU law professor Anna Offit, who was watching the trial closely, explained the appellate Batson standard precisely to Fox 4 Dallas after the verdict. She noted that while Batson challenges are rarely successful at trial, appellate courts conduct a very specific inquiry into whether prospective jurors of different races were questioned in the same way, asked the same number of follow-up questions, and whether similarly situated white jurors were kept while similarly situated black jurors were removed. That inquiry, she emphasized, has not happened yet. It is happening now, slowly, in the way that appellate processes always move. Former federal prosecutor Cully Stimson went on Fox News following the verdict and identified the Batson issue as the most significant ground for appeal in this case. He was not saying the appeal would succeed. He was saying this is genuine legal territory, not noise, and that appellate courts take Batson claims seriously when they are properly preserved on the record. They were properly preserved here. Michael Howard raised the challenge in open court. It was denied on the record. That denial is now reviewable by the 5th District Court of Appeals. And there is a second legal argument that the appeal is also likely to raise, which the reference material the prosecution's own case file has documented, the sudden passion issue. In Texas law, sudden passion is a specific legal doctrine that applies during the punishment phase of a murder trial. If a jury finds a defendant guilty of murder but then determines that the defendant acted under the immediate influence of sudden passion arising from an adequate cause, meaning they were provoked into a state of terror or extreme emotion by the person who died, and they acted in that moment without time for rational reflection, the maximum punishment is capped at 20 years instead of the full range for murder. During the sentencing phase of the Anthony trial, the defense asked the jury to consider sudden passion. They argued that when Austin Metcalf, who was significantly larger than Karmelo Anthony, made forceful physical contact with him, the 19-year-old reacted not from calculation or malice, but from an instantaneous panic response. A 130-pound teenager being physically struck by a 215-pound varsity athlete, they argued, is exactly the kind of situation the sudden passion doctrine exists to recognize. The prosecution countered forcefully. They argued that the evidence did not support genuine terror, that Anthony had kept his hands in his backpack from the beginning of the confrontation, that he had issued a verbal warning, that his behavior suggested preparation rather than panic. They argued that anger at being told to leave, or pride at being physically confronted, does not legally constitute sudden passion. The jury rejected the sudden passion argument and sentenced Anthony to 35 years. The appeal argues that the jury instructions around sudden passion were legally flawed, that the framework the judge provided for evaluating that doctrine was confusing or incorrect, and that a properly instructed jury might have reached a different conclusion during sentencing. This is a narrower argument than the Batson challenge, but it is a legitimate appellate claim if the defense can demonstrate that the instruction language deviated from what Texas law requires. Now here is something important to understand about how these two arguments interact strategically. The Batson challenge, if successful, results in a full reversal of the conviction and a new trial. Everything starts over. New jury, new verdict, new sentencing, All of the risk we discussed earlier, the possibility of a harsher sentence from a second jury, applies completely. The sudden passion instruction argument, if successful at the appellate level, would more likely result in a remand for a new punishment hearing rather than a full retrial. In other words, it might lead to a new sentencing determination rather than a new determination of guilt. That is a significantly different risk profile. A defendant who wins only on the sudden passion argument is not starting from zero on the guilt question. They are potentially getting a new sentencing proceeding with the murder conviction intact. That distinction matters enormously for how much risk is actually involved in pursuing the appeal, and for how the defense team is likely thinking about which argument to prioritize. Most legal observers who have followed this case believe the Batson challenge is the stronger argument and the one most likely to attract serious attention from the appellate court. But it is also the argument with the most explosive potential consequences if it succeeds, because a full reversal means full reset. There is also the financial dimension of this appeal that deserves honest examination. During the trial phase, a fundraising campaign raised more than $600,000 for the Anthony family's legal defense and related costs. That number was widely reported. People assumed it meant the family had resources to sustain an appeal. The pauper's oath filing tells a different story. Defending a first-degree murder case from arrest to verdict over 14 months is extraordinarily expensive. Private defense attorneys at the level of this case do not work for free or for small fees. Expert witnesses cost money. Private investigators cost money. The official court record, which is the foundation of any appeal and which must be obtained from the court reporter who transcribed every session of an 8-day trial, costs money. Administrative expenses accumulate over a year and a half of litigation. There is nothing in any public record to suggest the fundraising money was improperly used. The pauper's oath reflects where the family's finances stand after those costs were paid, not before. This is a common and expected reality in high-stakes criminal cases. The American criminal defense system is genuinely expensive in ways that consistently shock people who have never needed it. If the court approves the indigency declaration, Karmelo Anthony will receive a court-appointed appellate attorney. The quality and resources available to court-appointed appellate counsel in Texas vary, but the system is designed to provide constitutionally adequate representation regardless of financial means. Whether adequate and optimal are the same thing is a fair question, and one that criminal justice reformers have raised consistently about public defender systems nationally. Let us zoom out for a moment from the legal mechanics and try to sit with the human reality of where this case actually stands in June of 2026. Karmelo Anthony is 19 years old. He is inside the Texas Department of Criminal Justice, assigned an identification number, following an institutional schedule, navigating an environment that has nothing in common with the one he was living in just 14 months ago. He had a 3.7 grade point average. He was a team captain. He had 2 jobs. He was weeks from graduation. None of that is his daily reality anymore. His legal team, appointed or private, is building a brief for the 5th District Court of Appeals. That brief will take months to complete. The court will take additional time to review it. A ruling could come in 2027. It could come in 2028. In complex constitutional cases, these timelines extend further than anyone wants. While that process unfolds, Austin Metcalf's family continues to live in the aftermath of April 2, 2025. His twin brother Hunter accepted Austin's diploma on his behalf at graduation. His parents navigate every ordinary day with a permanent absence where their son was. They have already been through a 14-month legal ordeal that forced them to relive the worst morning of their lives in open court. The appeal means that ordeal is not over. It means they have to keep waiting, keep watching, keep bracing for whatever the courts decide next. Every development in this case pulls them back. Every headline, every appellate filing, every update on what the courts are doing with a conviction they watched being delivered brings them back to that tent, that rain, that morning. That is the cost that no legal brief addresses. The grief does not pause for appellate briefing schedules. It does not hold while the 5th District Court reviews voir dire transcripts. It runs continuously on both sides of this case, regardless of what any court decides. The public conversation around Karmelo Anthony has often treated this case as a symbol of racial injustice in the legal system or a symbol of accountability for violence depending on which direction the argument runs. Both of those symbolic readings contain something real. The concern about jury composition and the Batson doctrine reflects genuine documented problems with how the American legal system has historically treated black defendants. The insistence on accountability for the loss of a life reflects the genuine, irreversible reality of what the Metcalf family experienced. But Karmelo Anthony is not a symbol. He is a person serving a 35-year sentence, making decisions about whether to pursue an appeal that carries real risk alongside real possibility. Austin Metcalf was not a symbol. He was a 17-year-old who went to a track meet and did not come home. The legal system is going to take its time working through the questions this case raises. The appellate court will eventually issue a ruling. Whatever that ruling says, it will not resolve the grief on either side of this tragedy. It will not bring Austin Metcalf back. It will not give Karmelo Anthony's mother back the son she had before April of last year. What it might do, what the appellate process at its best is supposed to do, is answer the question of whether the rules were followed, whether the constitutional protections that exist to make the American legal system function fairly were honored in that Collin County courtroom. That answer is not available yet. It will not be available for months, possibly years. And when it comes, it will set in motion another chain of consequences that the people at the center of this story will have to live through again. There is a dimension of the retrial risk that the public conversation has almost entirely missed, and it deserves a direct, honest examination. Because understanding it changes everything about how you evaluate the choice to appeal. When people talk about the danger of a retrial after a successful appeal, the conversation usually stays at the surface level. Second jury, potentially harsher sentence, yes, understood. But the specific mechanics of why a second trial would be more dangerous for Karmelo Anthony than the first, not just theoretically more dangerous, but specifically, structurally more dangerous given everything that has now been made public about this case, requires a closer look. During the first trial, the prosecution had to build their case in real time. They had to select their witnesses, decide what to emphasize, construct their narrative about what happened under that tent, and anticipate what the defense would argue, all without having seen Michael Howard's full strategy play out in front of a jury. They made choices. Some of those choices worked extremely well. Some of them may have been calibrated based on assumptions about how the case would develop that the actual trial course challenged. The defense also made choices in the first trial. Karmelo Anthony did not testify. That choice, constitutionally protected, strategically defensible, but consequential, meant the jury never heard him explain in his own voice what he was experiencing in those seconds after Austin Metcalf made physical contact with him. They never heard his account of his own fear. The jury instructions were disputed. The sudden passion argument was made during sentencing. The Batson challenge was raised and denied during jury selection. All of that is now on the public record, analyzed in exhaustive detail by legal observers, attorneys, journalists, advocates, and anyone who has watched the multiple hours of coverage this case has generated. In a second trial, both sides would walk into the courtroom with complete knowledge of what the other had done the first time. The prosecution would know exactly where the defense's arguments were strongest. The physical size disparity, the contested sequence of contact, the ambiguity of the surveillance footage. They would know exactly where those arguments fell short with the first jury. They would have had additional time to prepare witnesses, to refine their presentation of the body camera footage and the testimony of the student witnesses, to address the physical disparity argument more directly. The defense would face a prosecution that has essentially already won this case once and knows how to win it again. They would also face a much more difficult jury selection environment. If the Batson issue is the basis for the reversal, the prosecution's next jury selection would be conducted with specific awareness that they cannot use peremptory strikes in a way that removes all black jurors from the pool. They would prepare differently. They would document their race-neutral reasons more carefully, question potential jurors more thoroughly, and ensure that their strikes could withstand the kind of scrutiny that the first jury selection did not face at the trial level. A second jury in this case, selected more carefully by a prosecution that has already navigated a successful appeal against them, would likely be more diverse than the first one, but that jury would also hear the same evidence, The body camera footage of Karmelo Anthony saying, "I'm not alleged, I did it," is not going away. The witness testimony from multiple students who described the confrontation and its escalation is not going away. The medical examiner's testimony about the nature of Austin Metcalf's wound is not going away. None of the facts change in a retrial, only the process does. And the sentencing range in Texas for a first-degree murder conviction is 5 to 99 years or life. That is the range a second jury would be working with. The first jury landed on 35. There is no legal mechanism that prevents a second jury from landing higher. This is not hypothetical. It is how the Texas legal system actually operates. Criminal defense attorneys who practice in Texas appellate law will tell you that this risk is real, that it is discussed seriously with clients before an appeal is filed, and that it shapes how defendants and their counsel think about whether to pursue an appeal and on what grounds. The pauper's oath changes the calculation slightly. If Karmelo Anthony is represented by court-appointed appellate counsel rather than private attorneys who were paid with donated funds, the financial resources available to the appellate team are different. Court-appointed counsel in Texas appellate cases are typically experienced appellate attorneys. This is a specialized field, and the state's system for appointing appellate counsel in serious felony cases draws from a pool of qualified practitioners. But the resources for things like expert consultants, investigative support, and the intensive review of a long trial record are not the same as what a well-funded private team would have. That is not a criticism of the system. It is an honest description of the practical difference. There is something else worth examining in the broader context of this case that speaks to the risk question in a different way. The comparison to the Case Allison case in Belton, Texas, has become central to the public argument about whether Karmelo Anthony was treated fairly by the legal system. Allison, who is white, was involved in a confrontation at a Texas high school in 2022 in which another student died from a knife wound. Allison claimed self-defense. The first punch was documented clearly on video as coming from the other student. Allison testified in his own defense. The jury acquitted him of murder and convicted him of criminally negligent homicide, which carried a maximum sentence of 2 years. Anthony, who is black, was involved in a confrontation in which the physical initiation of contact was disputed and documented by grainy, ambiguous surveillance footage. He did not testify. The jury convicted him of murder and sentenced him to 35 years. People who point to this comparison as evidence that the system treated these two cases differently based on race are raising a legitimate question. The structural differences between the cases, Allison's clearer video evidence, Allison's decision to testify, differences in how the respective cases were litigated, provide partial legal explanations for the different outcomes, but they do not fully explain the magnitude of the sentencing disparity and the absence of black jurors in the Anthony case, while the Allison case presumably drew from a different jury pool, adds another layer to the comparison that is difficult to dismiss. This is the context in which the Batson argument at the appellate level has to be understood. It is not just about the procedural mechanics of whether 3 peremptory strikes were race-neutral or pretextual. It is about whether a jury that contained no black members in a racially charged case produced a verdict that can withstand constitutional scrutiny. The appellate court's job is to answer the narrow procedural question. The broader social question about whether similarly situated defendants are treated similarly by the American legal system is one that the courts have to grapple with imperfectly in the course of answering those narrow procedural questions. The next year or more will determine what the 5th District Court of Appeals makes of the voir dire transcript and the Batson challenge. It will determine whether the sudden passion instructions are found legally adequate. It will determine whether Karmelo Anthony's conviction stands as delivered or whether it is sent back for another round of proceedings. Whatever that determination is, it will not end the conversation this case has started. Cases like this one, where genuine legal questions intersect with genuine social ones, where the grief of one family and the circumstances of another create a human reality that the legal system can only partially address, tend to live longer than the verdicts they produce. The legal record closes, the human record does not. True Crime Vault is going to be here for every development in this case as it moves through the appellate system. Every brief, every ruling, every update. Because the details matter, the legal mechanics matter. And the people at the center of all of this, Austin Metcalf's family in Frisco, Karmelo Anthony inside the Texas Department of Criminal Justice, both sets of parents trying to understand how they ended up in this particular story, matter more than any of the arguments about them. Subscribe, hit the bell, leave your thoughts in the comments. True Crime Vault. We will see you in the next investigation.